We're back on the record to continue our charge conference. I have made it easy. Mr. Fawcett, I respect the arguments you've made on lying in wait and felony murder. I think this is a premeditation deliberation case. I've read the cases. With the lying in wait issue, all of the things you have said are correct. The case law does support that, but I didn't find one case. We had either someone was not concealed, but was waiting on the side of the road in plain view for somebody to come by, or we had someone who was concealed who had that instantaneous element of surprise, the ambush, but I did not find sufficiently parallel facts that gave me comfort in that theory. With the felony murder, the evidence is fairly clear as to what the order of events was. The assault on Mrs. Hahn and then the assault on Mr. Hahn. I'm concerned again that relieving the jury of the task of determining premeditation and intent under this fact pattern is just simply too close to the line of a felony murder. I think it would be too risky to charge the jury, give them that option. I would, it simply seems to invite error when the risk need not be taken.
Could, yes, Your Honor, could I be heard on the felony murder a little bit more?
Yes, sir.
Judge, thank you. So over the lunch break, and I do have some cases here, but as to the felony murder, the first issue the state would see is, can assault with a deadly weapon, inflicting serious injury, be the predicate to felony murder? And the answer is yes. Starting back with State v. Terry. We'll jump to Jones, and I have a copy right here. Jones was the 2000 case that I may approach.
Yes, sir.
This was that motor vehicle impaired driving case where there's a crash and 6 people are in the car and multiple deaths. And it was a felony murder conviction with underlying victims being with this assault with a deadly weapon, inflicting serious injury, the deadly weapon being the car. And that was the predicate to allow for a felony murder conviction. Jones goes through the history of felony murder and then as to the assault with a deadly weapon, inflicting serious injury. And it was reversed for the fact that in that case, as you know, you can be convicted of felony assault either with intentionally committing a felony assault, which the state has here alleged, or culpable criminal negligence. It's always the DWI thing, your reckless conduct. That proposition's still the law, but they, out of fairness, basically they said felony murder cannot be predicated on anything, on any intent where there's culpable criminal negligence. You must have the intent to do the underlying act. So an actual assault, an intentional assault, which we do have here. The state's point of view. State v. Terry from North Carolina Supreme Court holds specifically that here's an example of a felony assault and a first degree felony murder. I may approach. This is a person shooting multiple people, and a felony assault in that attack is allowed to be used to justify felony murder. And I guess I don't know if it's Chief Justice Exum. I think it says Exum. Chief Justice Exum spelled out that there has to be an interrelationship between the assault and then the killing, but not a causal relationship. It goes into the continuous transaction doctrine. and finds that to be the case in a permissible felony murder conviction. As an aside, we know that, so the history is there for multiple assault victims being a predicate to felony murder. As long as the intent is satisfied, the intent to engage in that assault, not some criminal culpable negligence intent, which is not an issue here in front of us. As I mentioned before the break, in fact, single victim cases can have felony murder, and that machete case is machete to the lady and then you strangle her. That was a felony murder conviction, State v. Carroll, which is in our crimes book, State v. Carroll from the North Carolina Supreme Court in 2002. But that's a single victim case. I'm talking about multiple victim cases. The law allows the Class C assault to be the predicate. It requires the intent, the criminal intent to engage in that act, not culpable negligence, which we would have to prove here, the actual intent, which the state contends we have it. Then you'd have to find that it's in the continuous transaction, temporal. Let's see. I have a pretty good Rosenberg case here that goes in and points out the temporal order, the killing and the felony is immaterial unless there's one continuous transaction, and it is immaterial whether the intent to commit the felony was formed before or after the killing, provided the felony and the killing are aspects of a single transaction. This case, if I may hand up, involves, looks like more than one defendant going, if I may approach.
Yes.
Going to, looks like antagonize some victims underneath the bridge. And while one person's underneath the bridge, apparently shot one of them, and the other victim runs out, and they grab him and drag him out the street, pistol whip him, he dies, and these are one for the other in this case, allows for the felony murder conviction. And it talks about continuous transaction. The temporal order is not material. I thought those cases are address the legal foundations to allow for felony murder in our facts, and then factually to apply the continuous transaction doctrine. We know it appears the evidence is that Mr. Hahn returns around the 5 o'clock hour, if I'm off a few minutes, if it's 5:05 or a little before, but 5 o'clock, and by 5:19 we know Angela Cave is calling 911. And within that short period of time, you have Mr. Hahn's testimony of coming down and seeing the defendant standing over Ms. Hahn holding the knife and then turning and immediately attacking him. This would require, so that's the state's legal argument that the law allows for it, the facts would support it, and that, again, as to your concern, the intent, the state would absolutely have to prove the intent to commit assault with a deadly weapon inflicting serious injury under State v. Jones. That's my argument on felony murder. Factually, on the line and weight, I have and I don't know exactly maybe based on the court's comments, I don't know exactly the procedure when you're dealing with an unpublished case. Okay.
It can be persuasive authority.
Okay.
So.
You mentioned facts. This was a Wake County case where the guy and his wife are laying in bed and he's got a knife in the sheets, and apparently I've got it. I provide it. Jakeem Wilson. Let's see.
Are we being further on language, or are we opening
If the court allows, just responding to these.
Sure, I'll be glad to hear them on.
And this was his wife refused to kiss him, and he had a knife concealed in the bed and stabbed her, killed her. Factually, that's a 2010 case. Looks like it's from Wake County. I don't know, not sure who the prosecutor was, but Judge Height. That's the information I have. But those are the state's observations. And in the continuous transaction, I think as you look, that Freeman case is the drug case where 1 week after delivering the cocaine, you go back to the residence to get payment, you have a gun, and the killing results. That's a continuous transaction. You have the 3.5 hours between the murder and the arson. And State v. James, which I think involves, I have it here, committing the murder, and I think it's then you drive over, commit a murder, and then drive vehicles to another county, return, and at that time burn down the residence. And it looks like it's a 3.5 hour period of time, and that would be one continuous transaction, as I understand it from the research over the lunch period.
Are we reopening lying in wait, Judge?
You can respond to the, I mean, he's made an argument on, I'm happy to hear anything further you have to say. But.
Sure. With respect to the, I don't know if there's an order that you want to hear it, or if you'll leave it to me. He since we're, I guess, addressed the continuous transaction doctrine first. Legally, I guess, if you wanted to figure out a way to fit it in, which I think they're trying to have the court do, they're going with this argument that the assault on Nation Han is the underlying felony to give rise to the felony murder rule with respect to the charge against Ms. Han. If there were evidence that suggested that Mr. Broyhill's intent was to go to the house that day to attack Mr. Han with the knife, and in the course of going there, Ms. Han were like intervened in some fashion, or he had to, the evidence that he had to stab her so that he could commit the attack on Mr. Han, or she intervened prior to the attack on Mr. Han, then you have the continuous transaction doctrine. That's the, just because you find a few cases that say there's a reason to allow it, doesn't mean it fits with the facts of the case. In this particular case, for example, it's like talking about the ones, you know, where using the example of the guys in the car. If they're committing a felony in the car at the time and someone dies in it as a result of the transaction, they say you can apply the felony murder rule. I understand that, okay? I understand the logic behind it. But that doesn't apply to this particular case. If there was evidence, and that's if there was evidence, there isn't any, that Mr. Broyhill was going over to the house to commit some attack upon Nation Han, and that's never been introduced, suggested, remotely talked about, and in the course of doing that, Ms. Han were attacked prior to, then the subsequent attack on Mr. Han perhaps could be considered the underlying transaction under the continuous transaction doctrine to fit this under the felony murder rule. You just don't have the facts here. This is a P&D case. That's really what it is and what it was intended to do. to submit it under the felony murder rule under that theory just isn't supported by any evidence that the jury heard. We would respectfully ask that be denied. With respect to the lying in wait, lying in wait doesn't require a showing of P&D because P&D is sort of built into lying in wait. A person doesn't lie in wait unless P&D is there. I mean, that's what you do it for. Here's the problem with that, Judge, with that particular instruction. I mean, if the court's willing to stay with its initial announced ruling, I don't need to be heard on it. But if you're reopening it, looking for your proposed instruction. You know, the instructions to the jury cannot be separated in, you know, like where you can just do them piece by piece. You're instructing them on the law and all the law, both substantively and as to how they are to apply the evidence against the law. So you have to look at the whole thing, right? So I would point out to the court under 101.15 with respect to the credibility of witnesses, okay, which is on the first page of your proposed instruction under the third instruction, right? There's that section in the second part of that that talks about, the third part of that, talks about the tests that the jury can apply with respect to the evidence in the case, okay? If we're going to go with the lying in wait thing, then I'm going to renew my motion for a mistrial because I think now it becomes clear that what the state's intention was in trying to admit only the interview of our client on April 26th was for the sole purpose of trying to get an instruction on the lying in wait charge. Because that's the only evidence where there's this suggestion that the defendant went to the book bag, got a knife, took the knife out of the book bag and went and attacked Ms. Hahn from behind. Now, forget about the credibility of that statement for a minute. That's the only evidence of that statement having been made. And the state knew that there was a prior statement, the one from the 23rd, where Mr. Broyhill, which has not been admitted, and, you know, we won't have to rehash all that, but it wasn't permitted in by the court. Now, it's obvious, it seems now, what the state's intention was. The state's intention in, we respectfully submit, in picking up just the one statement of the 26th was for the sole purpose of trying to get this additional instruction. Because had they allowed had they introduced as part of the state's case the defendant's complete statement, which included the one of the 23rd. And Your Honor knows this because you've done an in-camera review of it, and it's part of the record through that in-camera review, because you have the transcript and the recording. Mr. Broyhill said very clear, and actually we have Detective Morse's testimony, although he's never allowed to give the answer. I think it's clear for the, tried to make it clear from the jury that no evidence was discovered or released to the jury that would suggest that Mr. Broyhill, prior to the 26th, had ever made a similar statement. And you know, not the jury, but you know as the court, that that is not what he said on the 23rd. You know on the 23rd that he said, I don't remember cutting Jamie. And he said that on 4 different occasions. And he never said that statement about going to the bag. He said parts. He said, I remember getting the knife. I remember bringing the bag. He remember, so there's that. But this whole thing about going and grabbing the knife, this is where the lying in wait comes from. Lying in wait is, yes, there's case law that says you can go into someone's house, and even though they know you're there, so you're not concealing yourself, if they don't know you've got a weapon and that you have that sort of presumed premeditation and deliberate intent, to wait till the person's back is turned, such as that statement that was given, and go to the person from behind and attack them. If you are going to let that instruction go in, then what you're doing is you're sanctioning the state's misconduct of only putting in that part of the statement on the 26th. The state then is abandoning their obligation. Because remember, Your Honor, we only have one obligation. Our obligation is to zealously defend our client. The state has a dual obligation. They have to present the case on behalf of the state as to the alleged crime, but they also have to do justice. That's been litigated and found. It's a requirement of the state to do justice, and you know that. So for them to just pick this portion, this one part of Mr. Broyhill's statements from the 26th, and use that when they know that he gave a statement saying that he didn't remember doing that. Now we get to the issue under 101.15, where the jury is allowed to apply tests. The test, the opportunity of the witness to remember the facts or occurrences about which the witness testified, and whether the testimony is consistent with other believable evidence in the case. So now the jury doesn't get to hear the other, they haven't heard the other believable evidence in the case. They may believe that he didn't remember the thing. And we know that there's the potential for taint, because there was the intervention of the minister going into the room, and that was acknowledged by Detective Morse. So the problem you have is if you allow a lying in wait instruction, what you're doing is you're allowing the state to basically engage in this act of abandonment of justice and this act of, I'm alleging misconduct because it's intentional. And therefore, the only other solution, and if the court is entertaining that, what do you call it, the theory of murder, would be then, if that were the case, the defense would respectfully move to reopen evidence, conditioned upon our ability to recall Detective Morse to the stand, and submit the statement of April 23rd in evidence for the jury to hear, and then if the state wants to renew its request for the lying in wait instruction, the court could rule on it. Without the statement of the 23rd going in evidence, respectfully, we would, and if the court's inclination is to give the instruction on lying in wait, the defense would renew its motion for mistrial, because that would be yet another denial of his right to a fair trial under the 5th, 6th, and 14th Amendments.
Judge, just finally on line and wait. The proposed state's instructions, I've underlined for y'all, for copies there, under the first element, elaborating. I've underlined the word attack and assaults, just so you know, those, we haven't gotten to this part, but the state, there is no premeditation deliberation built into line and wait. The case law is clear about that. It is only a physical act. There is no specific intent to kill required in that. The actual intent is to participate in the conduct that results in a homicide. The case law is clear on that. I was going to inform the court that the attack and the assaults, the purpose to kill her, you'll see often in the law where I've had underlined attack. That was the next thing to argue about, is not aware of his purpose to kill her. That, I believe, would be not accurate, given there is no specific intent to kill. This is to engage in an ambushed assault that results in a death. And I think the correct answer would be attack and assaults there, what's underlined. That's just, that would be well further down than what we're at. I just wanted to let you know that's the other reason that things are highlighted in my proposed instructions for line and wait.
No.
Briefly, Judge, I'll just respond to that. It is built in. It doesn't, maybe, and if I'm not articulating myself, I think you understand, but perhaps I haven't made myself clear to Mr. Fawcett. The P&D is built into lying in wait. That's what it means. What the case law is, I think what he's directing is that because it's built in, he doesn't have to prove it. If he's given a lying in wait instruction, he doesn't have to prove premeditation and deliberation, because you can't lie in wait for someone to do that without premeditating and deliberating. It's required. I mean, you can't lie in wait for someone and then, you know, ambush them and kill them without premeditating and deliberating to do it. That's why you don't have to prove that element. It's built into it. That's what it means. That's what, so when when they say you don't have to prove premeditation and deliberation, that's why. Because if you can prove that the person lied in wait, that's why it's there. It doesn't mean it's not part of it. It's built into it. That's all I'm saying. I'm not saying he has to prove it. He wouldn't have to prove it, because if he's proving lying in wait, he's in essence de facto proving premeditation and deliberation. It's just not an element.
As our Supreme Court has explained, quote, premeditation, deliberation are not elements of the crime of first-degree murder perpetrated by means of lying in wait, nor is a specific intent to kill. The presence or absence of these elements is irrelevant. State v. Leroy.
I think I just stated why it's irrelevant, but that's okay.
going to just simply go with the rule that the theory of first-degree murder will be with premeditation and deliberation, and sustain the objection or overrule the state's request that the other theories be offered.
Thank you, Your Honor.
Sustain the defense's objection. Now, turning to, I did change, I believe, 104.70 to 104.60, I think, in the version that you have now in front of you. Oh, I'm sorry, did you not get copies of those already?
Not yet.
Oh, well,
All right, we'll read your line.
yes, thank you. All right. So, so 104.7 has been changed to 104.6, admissions. The homicide is the same as what it was in the prior draft. The attempted first-degree murder is the same as it was in the prior draft. The assault with a deadly weapon, I've taken out the peremptory instruction that a 9-inch chef knife wound severing tendon and nerves is a serious injury, and that actually that should be a knife wound severing tendon and nerves is a serious injury if we're going to leave it in. But I'm.
Can we just start at 4th, is that what we're on page 6?
Right, and 4th. So in the draft you have, it just simply says the defendant inflicted serious injury, which was at the request of the state to remove the peremptory instruction that a knife wound severing tendon and nerves is a serious injury. Mr. Arbor, you argued that it should stay in so that the jury's not confused that you're not arguing that it's not a serious injury.
I think that was tied into the lying in wait charge, and since we're not doing that, it doesn't matter. I mean, we certainly aren't stipulating that, I'm sorry, not contesting that Mr. Hans suffered a serious injury. So, whether it's described or whether it's just put in at that, we have no objection to you just using this language.
All right, and if I do leave out the peremptory, I will go back. I need to go find the language that is part of the pattern.
Suffering.
Right, pain and suffering. But, Mr. Fawcett, I mean, do you still object to, I mean, given that the felony murder theory is out, I mean, do you still object to the inclusion of the peremptory instruction? I mean, Mr. Arbor's not contesting it. I think as a matter of law, it's.
The state's concern was for the felony murder being an essential element, and concerned about that.
I mean, I'm satisfied as a matter of law that this wound is a serious injury, so.
Yeah, and I guess, Judge, when you think about it, I mean, I really don't think jury, to be perfectly honest with you, but I mean, if you want to leave it the way it is, it's fine. I mean, the way you've got it now, I don't care.
Right. I would
It's
need
not
to
it's a
add,
non-issue for us.
right, I need to add, I'm going, as a matter of law, I'm going to find, I think it's my duty to declare what the law is, and I think as a matter of law, the law is that this wound that Mr. Hahn suffered is a serious injury as defined by our case law. So I think I'm going to go back to the prior draft with the one alteration. I have an 8-inch chef knife wound severing tendon. I think the description of the weapon need not be there. It's just simply a knife wound severing tendon and nerves is a serious injury. That would be what I would put in that spot.
Just basically the language you had before, right, Judge? Is that what you're saying?
Yes, sir. And the draft that you have that I gave before lunch, the second sentence of "and fourth" would be included, except I'm going to strike 8-inch chef. from
Oh,
that.
so just a knife wound,
A
okay.
knife wound. All right, in the draft that you have, the second draft, I've taken out the 204.25 aggravating factor instruction. And then those are all the changes that I've made.
Well, which means, I mean, just for the record, so no submission to the jury of the voluntary manslaughter, correct?
Correct, yes,
Right.
yes, I will not submit voluntary manslaughter.
That's fine, just no
Yes.
objection for the
Yes, sir,
record.
it's noted.
Thank you.
All right. Anything further? Yes, sir.
Judge, as to the page 4, neither premeditation or deliberation are usually susceptible to proof,
Yes, sir.
and may be proved by circumstances.
Where are we at?
Page 4, fourth paragraph.
Fourth paragraph, the one entitled fourth.
It's the fifth element,
Fifth element, fourth paragraph.
right, starting with neither premeditation.
Okay.
Judge, the state is fine with all those examples except one, and it has one to ask for. The infliction of lethal wounds after the victim has failed, I don't think the state would be asking for that instruction based
All
on
right.
at least the presentation of the evidence. There was one from the Supreme Court came out December 19, 2014 in this Childers case, and it points to the different examples of circumstantial evidence that may support the existence of the elusive qualities of premeditation deliberation. And it mentions what I believe to be the 7 ones that are usually mentioned in the pattern. Then it speaks to when evaluating the presence of premeditation deliberation, this court has additionally considered whether the defendant arrived at the scene of the crime with a weapon and whether he fired multiple shots. These examples are merely illustrative and are not to be treated as an exhaustive list of factors a jury may use to infer premeditation deliberation. In the state's written request, the wounds after the victim has failed, and did add in the highlighted language the request of whether the defendant arrived at the scene of the crime with a deadly weapon is something for them to consider. Here's I don't have it's actually a very short Childress case that came out December.
Is that our copy?
No, it's what I was going to show the court. I just read the paragraph. It's
I just assumed it wasn't, it might have been ours because it was in pink paper. So.
What's the citation? Is that?
Judge, if I could keep my hand this up.
Yes.
I don't think it had a citation. I know it has a citation, but it was right when it came down. You go on the.
Oh, okay, so it came out just,
web on the Supreme Court site. Circumstances. That's the only final state's request and observation.
All right, do you want to be heard on that, Mr. Arbor?
Yes, Your Honor, we would object to that. It's not in the pattern, and what it does is it sort of sanctions when the court adds it to the instruction, sort of, in a way, sanctions evidence that Mr. Fawcett can argue in his case in trying to prove that this was premeditated and deliberate. There's enough language in the pattern jury instruction for him to get to this. What he's looking for you to do is put language in the instruction that conforms solely to his theory of his case. These are fact issues that he's supposed to argue for premeditation and deliberation. It's not something that he needs to have incorporated as the jury finding that is an element sufficient to conclude that there's premeditation and deliberation. I mean, I understand that we can argue too that he brought the knife for a very different purpose, but it's really familiarizing the instructions, which are supposed to be somewhat neutral for the law, and I understand that these are pattern instructions, and I understand we do particularize our instructions to the facts of the case for other elements. But this one's kind of close to the vest, if you will. It's like he's trying to just have the court in its instructions sanction the evidence that he has chosen to present in his burden of proof. If you give the pattern, the room is there for him to argue it. He doesn't need to have it in the instruction presented to the jury for them to consider. And any deviance from the pattern on this particular issue, we would respectfully submit as a violation of our client's due process rights and right to a fair trial.
Mr. Fawcett, I agree. I think that the language, the conduct of the defendant before, during, and after the killing would cover the specific example. I think that
was a rather recent case that came down.
Right.
Yes.
And it does. I mean, I think certainly it suggests that the list of factors in the pattern instruction it's certainly not exhaustive, but I agree that there's sufficient room for you to argue that fact and match it to the language that's already in the instruction, sir. All right, very good. Any other?
The last point about failed, is that being taken out?
Yes, sir.
Based on
Infliction of lethal wounds after the victim has failed. Mr. Arbor, any objection to removing that language?
No. To removing it? No.
Yes. All right, so that'll come out. All right.
So it'll go from use of excessive force then to brutal or
Yes.
vicious? Thank you.
Correct.
Can you get a finalized copy of some?
Yes. Now, what I'll do, so it's my practice to provide the jurors with a printed copy of the jury instructions as I'm reading them. Either of you wish to be heard on that practice?
The state does not object.
No, I don't object to that.
All right. And what I will do is the copy they get, first of all, I'm going to proofread this one to make sure that I'm comfortable in giving it to the jurors. I will also, the headings are modified a little bit. I take out the actual numbers, 101.05, for example, and then there's some headings that include the word, for example, felony. I don't know if there are any in this, but yeah, like 208.10, it's assault with a deadly weapon with intent to kill, inflicting serious injury, felony. And I'll take out that word felony. So there may be some, between what the jury sees and what I get for you quickly, there may be some difference because I'll do that proofreading over the course of the afternoon and evening. But if you want a copy of exactly what the jurors will have, I can certainly get that to you within probably the hour.
That'd be great.
Okay.
Should we maybe leave a copy upstairs for us to pick up then?
I can do that. I
Is
can,
that how it works?
I can certainly do that by, say, about 4:30. I should have a copy. Terry is not there today, so it'll be just in my mailbox with your names on them. Two envelopes with your names on them, and that'll be what in my view will be the final set. All right. Now, let's see, yes.
Any, you want to probably, I don't know, wait, were you gonna, think about a verdict sheet, or were you gonna?
Yes, the clerk has, I haven't had a chance to look at it, but I know the clerk has put one together, so I'm gonna look at that.
You want to just include that in the copy?
What's that?
With the modified instruction, will
I
you?
can, if she has them ready now, I can. Do we have it back? Sorry. Oh. Yeah, if you want to just hand those first to Mr. Arbor and then.
Thank you. Pretty easy now.
It's two separate. So, okay, so Mr. Fawcett has one, you have the other, and they're different.
I got the one for Mr. Hines.
Right. So look at that one, and then in a moment, you'll, right.
I was just gonna check the file number.
Right. Yes.
Is that dealing with Mayor Pro Tem?
Yes, please. All right, so any objection to the form of the verdict sheet?
Not from the state.
All right, and then the final thing, let's talk about closing arguments. So the state will have the final closing argument. Mr. Fawcett, do you wish to make an opening?
No, Your Honor.
All right, so Mr. Arbor and Ms. Elliott, you'll have the first closing argument, and Mr. Fawcett, you will have the final closing argument. General Statute 7A-97 permits Superior Court judge to authorized to limit the time of argument of counsel to the jury in criminal actions to not less than 2 hours on each side. In felonies less than capital. Either of you feel that 2 hours is not going to be adequate?
State does not do that much time.
I mean, we haven't drafted it yet, but I don't envision that, if we went beyond it, it wouldn't be by much.
All right. Let me know if you reasonably think that you're going to extend that. Generally, there's a lot to cover here. I think sometimes it's helpful to inform the jury that there is, and the pattern instructions do provide some language for letting the jurors know that closing arguments made.
I will say this, Judge, at this time, we won't avail us. It sounds like from when you were extending the offer for both Ms. Elliott and I to make a presentation, was that correct? Whatever time we're allotted, I'll be doing the closing.
Okay, that's fine. So that's, I just wasn't presuming how you were going about it, but I generally will let the jurors know that lawyers are allotted up to 2 hours to make their closing arguments so that they can sit back and know that there may be a long argument. But on the other hand, I think that also serves the purpose of putting them on notice. When someone exceeds 2 hours, they start getting a bit antsy. So I would do that, and that's what I intend to do. But if you're telling me that you feel that you may need more than that, I have some discretion. But that would be my intention, is to limit it to 2 hours for both sides. All right, then we will. Is there anything else that we need to take up?
Judge, I've talked with Ms. Elliott yesterday, and I think Mr. Armour and I talked very well, specifically Ms. Elliott and I spoke on this exact point. Without objection, I do know I believe they intend to use the big screen and have various photos. They're into evidence, but they're not marked. They are the photos, and they might look a little cropped or differently. I have no objection. They come from the same source material. Likewise, I've told Ms. Elliott yesterday, the state will use the big screen and actually the TV probably, but we'll have similar photos. Some do have the state sticker and number on them that have been scanned in before trial. Others are photos that are into evidence, but they're not the state stickered photos. I'm told there's no objection. There'll be demonstrative Microsoft Word document. I'm not sure if that's the right word. Word documents that the state will use in closing, just putting people on notice that's what I'm going to do. And may play some audio from state's exhibits that I'm not walking over and getting the state CD that's in the evidence, putting it in the computer, and then queuing up it will already be queued up without the CD, and I can tell you after the fact the exact CD and the exact time period that covers. I wanted to put everybody on notice that's what the state, and I'm told that there's no objection. Specifically, me and Ms. Elliott spoke about that yesterday.
Any problem with that?
I'm been instructed I have to do for Ms. Elliott.
That's good. Good.
In the last thing from the state, the state's intention is if the state shows some photos of Ms. Hahn, some medical examiner photos, we won't be showing them on the big screen. We will just limit it to this small TV, just out of.
Right.
It's just my preference.
And will that be turned?
It's going to be sitting right there, turned to the jury, so people can see. I mean, that's not the reason why, but it will be sitting there. And
Okay.
the general public would be able to see some photos.
All right. I think that's fine. All right. Is there anything else that we need to take up beyond that?
No, I will give a short heads up. We will use the big screen for some things, and anything that we think would be best suited for the eyes of the jury, we will have a different way of presenting
That's fine.
it.
That's fine. So we'll have it on. Just Miss Elliott, you'll just need to let me know when you want me to switch to your laptop, because I generally don't keep your laptops on my screen. So just let me know when you want me to switch over, and I'll do that, and we can get you queued up. All right. If that's the case, then I'm going to go prepare a final draft of the instructions. I will put those in my box somewhere around 4:30, and you're welcome to come pick them up anytime after that. And we will then recess until 9:30 tomorrow morning. And arrange with the bailiff if you need podiums or whatever you need along those lines. Just let them know so we can have those ready to go.
Judge, I don't know how much control you have of that. Not a lot of need really for us to get back in here, but there's a comes a point in the evening where they have been locking the doors.
Even with the, coming in this way?
Yeah, they're like physically locked. I don't know if there's anything you can do about that. Just in case we want to get something set up so that we can be ready to go.
Oh, you mean earlier in the morning? You want
And security, they come around at night.
to, okay. What time is it unlocked in the morning?
Generally around 7, something like that.
Okay, so that's,
We'll just have to do whatever we have to do then.
right. Where would you be? You mean after 7? Okay. Here at 7:15, so if you have any trouble getting in, you're welcome to contact the clerk.
The state would be using the big home out what Mr. Arbor wants to do. Regardless when he's done, there would be some appreciable break or
Right.
something. Okay.
Right. And I don't generally take a break during the closings. I mean, that's.
Mid-closing, you mean? Or are you talking about
Right,
between
right. In
closings?
each, like, if you're going 2 hours, we'll probably just go 2 hours straight. In
Right.
other words, if I start getting hands waving and things like that, then we'll take a break. But so we'll just keep an eye on that. All right, very good. Then we'll be in recess until tomorrow morning at 9:30.
Vehicles have to be tested out there, or they'll say